Thank you, Chair. Isabel Goodman. I appear for BAIN. I'm led by Mr. Cockrell, who is available on Zoom.
Yes.
We are instructed by Mr. Bernstein of Baker McKenzie.
Yes, thank you. Good morning, Mr. Cochrane. I think he can't hear me.
Morning, Chair. Yes, morning, Chair. Sorry.
Yes, thank you. Yes.
Good morning, Chair. My name
Chair,
is
but I do confirm I act for BAIN Company. The act for BAIN Company South Africa Inc. Thank you, Chair.
Thank you. There is something wrong with how everything comes across when you speak. The technicians will try and attend to that. Yes.
Good morning, Chair. My name is Annette Mbuisa. I appear on behalf of Mr. Athol Williams.
Thank you. Thank you. Okay. All right.
Good morning.
Oh, there's somebody else. Yes.
Thank you. Good morning, Chair.
Good morning.
I'm Max DPC. I'm appearing on behalf of Mr. Sipho Maseko and Jabo Mabuza. I'm instructed by Nortons Incorporated, and I'm accompanied by my attorney, Liacho Matabate, sitting next to me.
Thank you, Mr. Duplessis. Okay, let them sanitize before you go there. Just wait, somebody will sanitize first.
Thank you. Good morning, Chair.
Good morning.
I'm sorry, I had to come down. My mic is not working.
No, that's fine.
My name is Ndumisa Zwane. I am representing Messieurs Mwako Rapolo and Million Mbata, the employees of SARS.
Okay, thank you.
Thank you.
Thank you. Okay, Mr. Franklin, unless there's still somebody else, I think we have exhausted the list.
Thank you, Chair. If I may then proceed to outline the program for the next 3 days. That's today is the 23rd, the 24th, and the 25th of March.
Yes.
As I indicated to the Chair, this week the Commission will hear evidence regarding the South African Revenue Services. And in our contention, the SARS evidence is central to the Commission's mandate to inquire into allegations of state capture. SARS has featured prominently in allegations of state capture, and it will be contended that the actors in question weakened and misdirected operations of SARS, particularly its compliance functions, rendering it less effective and all for unlawful purposes. And accordingly, the SARS evidence falls squarely within the Commission's terms of reference. A particular feature of the SARS evidence, Chair, is its connection with the so-called Nugent Commission. As the Chair will be aware, the Commission of Inquiry into Tax Administration and Governance by the South African Revenue Services, known colloquially as the Nugent Commission, operated under terms of reference published on the 18th of June 2018, and the Commission was required to inquire into, make findings on, and report and make representations concerning 18 specific issues. Chair, there is an overlap between the work of that Commission and the present Commission. The Nugent Commission focused on irregularities at SARS, including what it found was the seizure of SARS by Mr. Tom Moyane and others, whilst on the other hand, this Commission is, of course, investigating state capture of public entities, including SARS. So the central question to be answered by the State Capture Commission fell outside of the scope of the Nugent Commission references. To determine the correct guiding or dividing line between what is a permissible topic of inquiry for this Commission and what is not, because it has already been dealt with, it's necessary to consider briefly what was investigated and found in the Nugent report. And in the final report, the Nugent Commission made the following overarching findings. The first was that there had been a massive failure of integrity and governance at SARS, demonstrated by what SARS once was and what it has become. That state of affairs, so it was found, was brought about by the reckless mismanagement of SARS on the part of the former Commissioner, Mr. Moyane. What occurred at SARS, said the Nugent Commission, was inevitable the moment Mr. Moyane set foot there, because he dismantled the elements of governance one by one, and that was described by the Nugent Commission as seizing control of SARS as if it was his to have. Furthermore, the failure of good governance was manifest inter alia from the fact that senior management was driven out of or marginalized at SARS. Senior management appointed by Mr. Moyane were simply compliant and neglected their oversight function. The development of SARS's sophisticated information technology systems was summarily halted. The organizational structure of SARS that provided oversight was pulled apart. Dissent was stamped out by instilling distrust and fear. Accountability to other state authorities was defied, and capacity for investigating corruption was disabled. And then finally, instead of fostering a climate and a culture of healthy dissent, the Nugent Commission found that Mr. Moyane engendered a culture of fear and intimidation, and there was a purging of competent officials. Now, Chair, I have no doubt that this Commission has no desire to repeat the work of the Nugent Commission, nor does this Commission seek to re-enter the fray on the same basis. In the absence of any judicial review of the Nugent Commission's report, those findings, of course, stand, and no evidence in contradiction of any such finding we would submit should be admitted. While the remit of that report was wide, there are certain issues which were not investigated by Judge Nugent and which are now the focus of this Commission's work in relation to SARS. And matters concerning SARS which were not within the remit of the Nugent Commission's work, or in respect of which evidence was not led, and which are relevant to this Commission's inquiry, will properly form the subject matter of testimony this week. And so, Chair, the focus will be on the consulting company BAIN's actions in connection with SARS, and Chair will recall that the Nugent Commission concluded that BAIN had not told the full story. Secondly, there will be an emphasis on Mr. Moyane's role in SARS, and it will be recollected that Mr. Moyane did not give evidence before the Nugent Commission. And then thirdly, evidence of the impact of the capture of SARS upon the institution. And so, Chair, whilst the Nugent report makes detailed findings as to the institutional dismantling of SARS, this Commission's mandate requires that the strategic significance of this capture of SARS be contextualized within the big picture of the state capture inquiry. If I could briefly then just highlight for the Commission the patterns and processes of state capture and where the evidence that will be led fits in. The Nugent Commission's findings and the evidence led showed that the repurposing of SARS followed familiar patterns and processes of state capture that have been observed in other state institutions. And SARS offers, we would submit, one of the clearest demonstrations of this pattern of repurposing observed in other state-owned entities and state institutions. And this includes, so the evidence will show, the collusion between SARS, the executive, and BAIN with a planned and coordinated agenda in relation to SARS well in advance of either BAIN or Mr. Moyane's appointment. Secondly, the purging of competent top officials and the climate of fear. Thirdly, the strategic positioning of compliant individuals. And fourthly, the restructuring and deliberate weakening of institutional functions. And all of those are common features which this Commission has heard in relation to other institutions. In addition, we will contend that the evidence to be led bears out the pattern of procurement irregularities, which have so far loomed large in the evidence heard by this Commission, and that would include the collusion in the award of a contract, the irregular use of confinement and condonation to avoid open competition, transparency and scrutiny, and thirdly, the use of consultants to justify changes that were really only necessary to repurpose SARS. Chair, the witnesses that will be heard this week are as follows. Firstly, today, the Commission will hear from Mr. Athol Williams, who is a former BAIN Company employee. Secondly, tomorrow, we will hear from Mr. Vlok Symington, who is a senior employee of SARS. Thirdly, Mr. Johan Van Lochenberg, who is a former SARS employee. And then finally, on the 25th, from Mr. Tom Moyane, the former commissioner of SARS. And then, Chair, an arrangement has also been made that Mr. Moyane will conclude his cross-examination of Minister Gordhan in an evening session which has been set for today, the 23rd of March. If I may then briefly take the Commission to the essence of the evidence that will be led. In relation to Mr. Athol Williams, as I have indicated, he was a BAIN Company employee. He was employed in various roles. The ones we are interested in for purposes of the Commission today are, firstly, that he was engaged as an independent consultant from September of 2018 to December 2018 to oversee an investigation that had been commissioned by BAIN into the award of the contract with SARS and the work which it did at SARS. Then from January of 2019 until May of 2019, he was employed as an independent advisor to develop a so-called remedy plan for BAIN. Then thirdly, from May of 2019 to August 2019, he was employed on a part-time basis as a partner serving on the BAIN Africa Oversight Board. And then fourthly, he resigned at the end of August of 2019 because he was of the view that BAIN had not been transparent with him and the South African authorities regarding their investigation into what happened at SARS under their tenure. And he made various media statements in 2019 that BAIN was withholding information about the restructuring at SARS and their work at SARS. Mr. Williams was approached by this commission for an interview which was held. Pursuant to that, a summons was issued against him to produce books and documents, which he did, and subsequently he furnished the commission with an affidavit dated the 23rd of July 2020 and annexes thereto, and that will form the basis of the testimony that is to be produced today. Chair, you are aware that BAIN launched an application which is to be found in file SEQ 44/2020. In it, they applied for leave to cross-examine Mr. Williams, leave to make oral and written submissions to the Commission, and then also an order that confidentiality...
Just 1 second, Mr. Franklin. Yes, you may continue.
Thank you. Chair, the application asked for various relief, as I have said, and the third prayer was that confidentiality be maintained over certain portions of Mr. Williams's affidavit and its annexures, and for those to be withheld from public disclosure. I'm happy to say, Chair, that in discussions with my learned friend, Mr. Cockrell, we have managed to narrow the ambit of that application considerably. You will have seen that there was an Annexure X which was updated, and that had various categories, and in relation to each of those categories, BAIN had originally asked that the evidence be kept confidential. In relation to the first of those sections, so-called sensitive personal information regarding whistleblowers, it's been agreed that the personal details of two persons who are referred to in the affidavit will be redacted and not referred to. In relation to the other two people, Mr. Williams will say that he has been given specific permission by those people to reveal their identities. So that has been dealt with. In relation to the category of so-called legally privileged materials and information included in the affidavit, there was a relatively long list. I understand that BAIN will persist and place on record that they still regard certain of the information to be led as privileged and confidential, but they do not seek any relief in relation thereto, and Mr. Cockrell will no doubt outline that for the Commission. Then in relation to the so-called commercially confidential information, that too falls within the same ambit of the agreement, i.e., although it is maintained that it is commercially sensitive, and no relief will be sought in relation to that. And the final category was investigations by foreign regulatory and other bodies referred to in Mr. Williams's affidavit, and the approach of the Commission is that there is no reason not to refer to those investigations. I understand that BAIN will contend that they ought not to be referred to, but there is no specific relief that is sought in relation thereto. And then that really deals with the application in its totality, and the Chair has indicated to BAIN via the Secretariat that the application for leave to cross-examine and to make oral and written submissions will be dealt with in due course on a date to be arranged by the Commission. The sole remaining issue then regarding BAIN and what it requires is a request which was directed to the Commission in a letter dated the 26th of November 2020, in which it seeks permission from the Commission that affidavits which set out its version of events concerning its role at SARS be publicized by some or other means at the same time as Mr. Williams's testimony is uploaded onto the Commission's website. I understand Mr. Cockrell will motivate that particular request. The approach of the legal team is that there is no basis to accede to that request. So that is the position in relation to Mr. Williams and the BAIN application. There have been various other responses to Mr. Williams's affidavit. There have been letters which have been received, as well as affidavits which have been filed, and applications to cross-examine. I need not go through all of those. They are collected together in one of the SARS bundles, and the representatives of certain of those persons have placed themselves on record. Proceeding then to the second of the witnesses who will give evidence this week, that is Mr. Vlok Symington. He is currently an employee of SARS and a senior legal advisor. He is represented, and tomorrow the representatives will place themselves on record. he was asked by the Commission to submit himself to an interview in connection with an incident which has been described as a hostage incident that occurred at the SARS offices in October of 2018. And he ultimately provided the Commission with an affidavit dated the 2nd of November 2020, which will be the subject matter and focus of his testimony. And consequent upon that, various other people also gave affidavits, which are also bundled in the SARS bundle. Similarly, such applications as there are to cross-examine, as well as Mr. Symington's own application to cross-examine various people, will be, as I understand it, dealt with by the Chair on a date set by the Commission. The third witness is Mr. Johan Van Lochenberg, who, as I've said, is a former SARS employee. He was also approached by the Commission regarding the Commission's investigation into compliance units at SARS and the fate of those units and how they have been affected by the restructuring which took place under BAIN and Mr. Moyane. And he provided the Commission with an affidavit dated the 11th of November of 2020, which will be the subject of the testimony that he will present. There have been various applications which have been served in relation to Mr. Van Lochenberg's testimony. We are in the process of attempting to resolve those if we can. If not, then the Chair will be asked to hear and determine those applications. Chair, apart from that, there are bundles which have been prepared and which are before the Commission. Returning then to the proceedings for today, I understand that the Commission would first like to hear BAIN's requests, and that will be done via Mr. Cockrell. Thereafter, I will lead the evidence of Mr. Williams, and following that, in the evening session, the cross-examination of Minister Gordhan by Mr. Moyane's representatives will take place. So, against that background, Chair, may I ask that we deal with the residual BAIN issues and invite Mr. Cockrell to make his submissions.
Thank you, Mr. Franklin. Mr. Cockrell, are you ready to address me on BAIN?
Yes, thank you, Chair.
Yes, you may go ahead.
Sorry, Chair, I heard you say, invite me to address you, and then I'm afraid it went dead on my side. I couldn't hear what you were inviting me to address you on. I apologize.
Oh, no, on the BAIN application. That's what I said.
Thank you. Thank you, Chair. Chair, I won't have to detain you for very long. I'm very grateful to my learned friend, Mr. Franklin, for that very fair summary of where we are. I need to address you on two issues. I need to bring you up to speed with where we are on the confidentiality application. And then I need to address you very briefly on the application by BAIN in order to publish its own affidavits. May I address those in turn? Chair, you'll know the application by BAIN and Company had a number of prayers in the relief. Prayer 4 sought relief in relation to confidentiality. As my learned friend, Mr. Franklin, pointed out, there was an annexure to the notice of motion, Chair. It was a long annexure, Annexure X. We, BAIN, reduced that annexure in the course of last week. And in the course of Friday, we've reduced it even further, Chair. So what has happened is there's no longer any point of contestation between us and the Commission regarding the various categories of documents. And Chair, I need to make it clear, the reason why BAIN and Company has effectively decided not to persist with that application is it's very conscious of the fact that this commission is working under time pressure, and it wants this commission not to feel that it is being obstructionist or trying to obstruct the working of the commission. And so where Bain and Company comes out is this, Chair. If you were to go to Annexure X in the amended version, I'll go through those categories very briefly. It's largely in alignment with what my learned friend Mr. Franklin said. Annexure X really had 4 categories. The first category was sensitive personal information included in Mr. Williams's affidavit. And the view taken by Bain is that because those 4 people hadn't given consent for their identity to be disclosed, their identity was therefore confidential. We are now told by the evidence leader that Mr. Williams has permission from 2 of them. And so the agreement we've reached with the evidence leader, Chair, is that the identity of the remaining 2 will be anonymized. But there's agreement between us in that regard, Chair. We don't seek a reading from you. Chair, the second of those categories, the privileged information, Chair, I need to place this on record. You'll know that Mr. Williams came into possession of various documents in the course of his employment by Bain and Company. And the view taken by Bain and Company is that some of those documents are privileged. Chair, I see my screen is frozen. Are you still there?
We can still see you. We can hear you.
Thank you, Chair. Chair, those documents in some cases came from the external legal advisors to Bain and Company, Baker and McKenzie. In other cases, they came from the in-house advisors to Bain and Company. In many cases, those documents are called privileged. They are labeled privileged. The view taken by Bain and Company is that those documents are privileged and remain privileged. But Chair, for the reasons I've given earlier, Bain no longer seeks any ruling from you regarding the confidentiality of those documents. Chair, I say again, Bain and Company doesn't wish to hold up the workings of this commission, and so it has agreed not to persist with that application. In short, we assert privilege over those documents, but Chair, we no longer seek a ruling from you in relation to the second category, legally privileged documents. Chair, the third category, commercially confidential information, again, Bain and Company has decided not to persist with that application. We no longer seek any ruling from you regarding the confidentiality of those documents. And Chair, then finally, the fourth category, investigations by foreign regulatory and other bodies. Chair, those are allegations in Mr. Williams's affidavit, which refers to interaction between Bain and Company and regulators in other jurisdictions. The view that Bain and Company took is because those regulators regarded the interactions as being confidential, it was not within the power of Bain to waive confidentiality. And so we had a discussion with the evidence leader last week, and we ascertained whether the evidence leader was comfortable eliciting the fact of those interactions. And the view taken by the evidence leader is that the commission had no difficulty in that regard. So Chair, the position of Bain and Company is it regards those interactions as being confidential, but it no longer asks for any relief from you, Chair. In other words, if the evidence leader has no difficulty eliciting that information, Bain and Company doesn't seek any ruling from you regarding confidentiality in that regard. And so, Chair, where all of that goes is we're in the, may I say it, happy position where no ruling is sought from you in relation to any of the confidentiality portions of the Bain and Company application, Chair. There's agreement between ourselves and our learned friends, Mr. Franklin, as to how the evidence will be led, and we don't seek any ruling from you. I've simply placed on record what the position of Bain and Company is. Chair, that then brings us to the second part of what I have to address you on, and here, unfortunately, we do seek a ruling from you. Chair, you won't find this in the Bain and Company application. This is, in fact, something that was contained in the letter written by Bain and Company to the Commission on the 26th of November, 2020. And Chair, the position is this. Bain and Company has submitted 2 affidavits to you.
I'm sorry. Mr. Franklin, do you have a copy of that letter? The letter of November 2020 that Mr. Cockrell is referring to
Yes, Chair.
Or is it in the bundle here?
Yes, I will endeavour to locate that for you.
Okay,
and
all right.
Bring it to your attention.
Yes, you may continue.
Yes, apologies, Chair. I can't refer you to the bundle because I don't have it, but I'm going to summarise the letter as fairly as I can, and I'm sure my learned friend, Mr. Franklin, will make it available to you in due. Chair, the position is this. Mr. Williams filed his affidavit, his witness statement. When Bain and Company applied to you for various forms of relief, Bain and Company put up 2 affidavits, one from Mr. Min and one from Mr. Moolman. And the difficulty that Bain and Company now finds itself is this. It is simply not sure whether it's in a position to publish those 2 affidavits once Mr. Williams commences his evidence. And Chair, that is the basis of the relief we seek from you today. What Bain and Company is asking for is permission from you that Bain and Company, can publish those affidavits. My learned friend, Mr. Franklin, with respect, misunderstood it. He seemed to think that we were asking you for an instruction that the Commission must publish the Bain and Company affidavits. But that's no part of our relief, Chair. We don't ask the Commission to do anything. All that we ask for is permission that Bain and Company, should it decide to do so, can publish its own affidavits in any form it considers appropriate. And Chair, the reason why we ask that relief from you is if one goes to regulation 11.3b, Chair, not the rules of this commission, these are the regulations. Regulation 11.3b is drafted in with respect to a slightly obscure form. This is what it says. It says, no person shall, without the written permission of the chairperson, and then A says, disseminate any documents submitted to the Commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such document. So, Chair, what the regulation is saying is no person shall, without your written permission, disseminate any documents submitted to the Commission or publish the contents of any such document. And Chair, may I say a contravention of that provision is a criminal offence in terms of Regulation 12. Now, Chair,
I'm sorry, what regulation is it again?
Chair?
What regulation is it again?
Chair, it's Regulation 11. Regulation 11, sub E, sub A.
Oh, okay, okay.
So, Chair, when one reads that regulation, it's not immediately obvious whether it prohibits Bain from publishing its own affidavit. It's the Bain affidavit, but Bain submitted it to this commission. On one reading, what the regulation is saying is that Bain is prohibited from disseminating that document, its own affidavit, because it has published it to the commission. But Chair, even if that is not the correct reading of that regulation, the difficulty Bain would still find itself in is the Bain affidavits are, of course, referring to Mr. Williams' affidavits, which were also submitted to this commission. So even if Regulation 11.3a doesn't prohibit Bain from publishing its own affidavits, it would still have that effect in as much as the Bain affidavit is cross-referring to Mr. Williams' affidavit. And so, Chair, that is the purpose of today's application. The view taken by Bain.
Mr. Cochrane, let's just try and see if we understand what paragraph A says. There are two possible interpretations, it seems to me. There is no doubt that the prohibition relates to any document submitted to the Commission. So Bain's affidavit, once it has been submitted to the Commission, would fall under that. And then it says document by any person in connection with the inquiry. I suspect what you are saying is that the reference to any person is not a reference to a document of the person who seeks to disseminate the document. I suspect that's what you say. So yes, that might be one possible interpretation. Another one might be that the prohibition is intended to make sure that any document that has been submitted to the Commission, even your own document, you may not publish without the written permission of the chairperson. Now, on the face of it, the interests that would be sought to be protected by that prohibition are the interests of the investigation of the Commission. So if that is correct, then there may be difficulty in the interpretation that would say, I am free to publish my own affidavit that I've submitted to the Commission, and I'm free to do so without the written permission of the Commission. Because the mischief that is sought to be avoided would be the same whether I'm publishing or disseminating my own affidavit or disseminating somebody else's affidavit. I think that might be the difficulty with that interpretation. Whereas if we adopt the interpretation that the reference to any person includes the deponent to that affidavit or the author of that document, then that interpretation seeks to make sure that any document that has been submitted to the Commission is now part of the Commission's investigation. And to protect the investigation of the Commission, nobody should disseminate that document without getting the written permission of the Commission. I would be inclined towards that interpretation rather than the one that says as long as it is your affidavit, you can publish it even if you have submitted it to the Commission. But you might have something different to advance, or you might say whatever the correct interpretation is, this is what you would like to say.
Chair, with respect, from our perspective, it doesn't matter which interpretation is correct. May I say, with respect, you're entirely correct, Chair. Regulation 11.3a could be read as prohibiting the author of the document from publishing his or her own document, or it could be read as only referring to a third person. But Chair, from Bain and Company's perspective, it really doesn't matter, because Bain and Company has written to you seeking your permission, so that no matter...
Okay, so we quickly dip out of those proceedings at the State Capture Commission of Inquiry to take you to the Durban Magistrates Court.
The interpretation is correct. The prohibition falls away if the chairperson gives written permission.
Yeah.
That is what Bain and Company was saying to you in the letter, Chair. Bain and Company was saying, perhaps the regulation doesn't apply to Bain and Company's own document. But even if that were correct, Bain and Co. would still have a difficulty, because it would certainly apply to Mr. Williams's affidavit. And Bain and Company is referring to Mr. Williams's affidavit. So, Chair, with respect, on either interpretation, it really doesn't matter from our perspective.
I think there is...
On either interpretation, what Bain and Company is asking for.
I think the reason why I was looking at the two possible interpretations, I thought that could have been behind your emphasizing that Mr. Franklin may have misunderstood your position to be that you were asking the Commission, you were asking for my permission to allow the Commission to disseminate or publish. And you were saying, no, that's not what you are asking. You are asking to be allowed to publish yourself. So I was wondering what the significance is in terms of the difference, whether the publication is done by the Commission or by yourself, because in the end it is publication. So I was wondering whether there was any significance to be attached to that is based on the regulation. But I think it's clear that you are saying whatever the interpretation is, you want to make sure that if the correct interpretation is that everyone who wants to publish a document that has been submitted to the Commission needs the written permission of the chairperson, you want to make sure that you are on the right side of the law. So that I understand now. Yes.
That's quite correct, Chair. So the letter was written out of respect to your workings.
Yes.
What BAIN and Company were saying in the letter is there may be some interesting debates about how one interprets Regulation 11.3a, but he doesn't want to have those debates. He just wants to be on the right side of the law. And so the letter was written out of respect to you, Chair. And so, Chair,
I think that maybe
it really comes down to this.
It will help you. Hello, Mr. Cocker. It will help you.
Sorry.
If you have an idea what I have in mind, my immediate concern is why that should be done in this case, whereas normally it's not done. But of course, you may say, well, other people have not applied for the written permission. We have applied for written permission. But that was my immediate reaction to the request. And why?
I don't know what other parties have done.
Yes, I'm terribly sorry. There's something not so good with the technology. So you obviously will address that, but what has been happening over the past 3 years is basically that an affidavit will become public when the witness or the deponent to that affidavit has given evidence in public. Now, why should we not stick to that in this case?
Yes, Chair, firstly, may I apologize? I don't intend to interrupt you, obviously, but there's a big time lag between on the Zoom connection, unfortunately. So I do apologize if it looks like I'm interrupting you. I have no intention of doing that.
Yeah, no, yeah.
Chair,
I'm sorry. I think maybe we might have to adjourn to see whether the technicians can solve this problem. I'm sorry, Mr. Cockrell. We might have to adjourn a bit to see whether the technicians can solve this problem. I think there is both a delay, but also I don't know whether they say the network is unstable and whether that can be fixed. Should we adjourn? 5 minutes. Okay, let's adjourn so that our exchange can flow smoothly. We'll adjourn for about 5 minutes to give the technicians the opportunity to fix the problem. We adjourn. I've looked at it. Subject to what you might say, I don't see anything that justifies that BAIN be treated differently from everybody else in that letter.
Well, Chair, may I address you on why that would cause a difficulty for BAIN?
Yes.
Mr. Williams?
Yes. Oh.
Will give that Mr. Williams's affidavit would then be released.
Oh, hang on, Mr. Cochran.
But the difficulty for BAIN is, although it has a privilege...
Hello? I'm sorry, we couldn't hear you for a few seconds, so I think start afresh, please.
Yes, Chair, I do apologize. Chair, Mr. Williams will give his evidence today. As I understand what you said before the short adjournment, the practice of the Commission is that Mr. Williams's affidavit would then be released into the public domain. Now, Bain and Company has applied for leave to cross-examine. We don't know whether Bain...
We continue to have problems in terms of technology. There are times when I can't hear you. I'm looking at the technicians whether they need some time. I mean, I don't mind if we don't see you as long as
I turn my video off. That sometimes helps.
If it does, it's fine.
Sometimes that frees up some bandwidth, Chair. I've turned off my video.
Yes. Okay, maybe start afresh. Just start afresh and let's continue and see.
Yes, Chair, I do apologize for this. I really do.
No, that's fine. That's fine. I think you had just started saying the problem for BAIN, if it was to be treated in accordance with the practice that we have, would be, and then I couldn't hear. I think you can start from there.
Let me back up. What you put to me is that the practice of the Commission is once a person gives evidence before this Commission, its affidavit will then be released into the public domain. That's what I understood your statement to be about the practice of the Commission.
Yes.
So what that means is when Mr. Williams gives his evidence today, his affidavit will then be released into the public domain. But the difficulty for BAIN is, although it has applied for leave to cross-examine Mr. Williams, it hasn't yet been granted leave to cross-examine, and indeed it doesn't even know when its application for leave to cross-examine will be heard. And so the difficulty is, if someone today were to ask BAIN at the conclusion of Mr. Williams's evidence today, what do you say about Mr. Williams's evidence? What BAIN would want to do in the ordinary course is to say, well, see the two affidavits we have filed with the Commission. But Chair, with respect, if the narrow reading of Regulation 11.3a is correct, it means that BAIN can't do that. So they can't refer anybody to the affidavit they've filed. And it may be even worse than that, Chair, because if BAIN is advised that it can't release its affidavit, it may be in a position where it can't even summarize what it says on an affidavit, because that may also be seen to be in contravention of Section 11.3a. And so the difficulty for BAIN, Chair, is although it has filed affidavits before you, it doesn't know when its application for leave to cross-examine will be heard. And so with respect, if you were to refuse the permission, Chair, which Regulation 11.3 permits you to grant, it would in effect leave BAIN in a most untenable position where it is unable to respond, if anyone were to ask it, what is your response, Bain and Company, to the evidence of Mr. Williams? And Chair, you'll know the evidence of Mr. Williams says some pointed things about Bain and Company. And so, Chair, with respect, where all of that comes out, in our respectful submission, it's just a question of fairness to Bain and Company. I say again, we aren't asking to publish on the Commission's website. That's no part of the relief Bain and Company asked for in the letter to you. All that Bain and Company wants to do is, if asked by a client or by a media representative, what is your response? It wants to be able to refer to the affidavit it has filed. And Chair, with respect, that is just a matter of fairness to Bain and Company, because without it, Bain and Company is in effect left in a position where it is unable to respond to what Mr. Williams has said. And that just doesn't seem fair, Chair, in our respectful submission. Precisely because Bain and Company doesn't know when its affidavit will be released in accordance with the practice that we've referred to, Chair.
If
So,
you spoke about, I'm sorry,
minutes.
you also spoke about the possibility of Bain preparing a summary of what its response is, as opposed to publishing the actual affidavit. It may well be that that's better than publishing the whole affidavit. I'm not sure, but if that were to happen, would that not satisfy the fairness requirement that you talk about, to say, well, at least here is a summary of our response? What do you think about that as an alternative to publishing the actual affidavit?
May I say, with respect, it would certainly be better than nothing. It may, the very possibility you posit to me, Chair, would probably still require your permission, because Regulation 11.3a prohibits a party without your written permission from publishing the contents or any portion of the contents of such a document. So, Chair, I understand what you're putting to me is, well, if Bain and Company is refused permission to release its entire affidavit, could it not at least prepare a summary of its affidavit? And my response is that would also require your permission, Chair, under Regulation 11.3a, and at a bare minimum, that is what Bain and Company would ask for.
Yes.
But Chair, what I would say, and I make this submission with respect, is in some ways it's worse for the party. The party has gone on affidavit to put its version. It's now forced to cull that version on affidavit and try and give a potted summary of that version. In some ways, Chair, the likelihood of inaccuracy is greater when a party tries to summarize its affidavit than if it simply releases the whole affidavit. But Chair, I do take your point. What you're putting to me is, if the practice of the Commission is not to allow a party to release a document, including its own document, before it gives evidence, then what you put to me is, well, would it not at least be fair to Bain to be able to release a summary of that affidavit? And at a bare minimum, Chair, that is what we would ask for.
Yes,
so
because
the first price, Chair, would still remain for Bain to be able to say, here's the affidavit. But Chair, with respect, if you're not minded to grant that, at the minimum, we would at least ask for permission to release a summary of that affidavit.
Yeah, you see, what I'm thinking is that if one moves from the premise that the mischief sought to be avoided by the regulation is possible interference or impediment of the investigation being done by the Commission, it may be that the publication of a full affidavit with all kinds of details might be more problematic compared to a publication of maybe a summary of what the response is. That's what I'm thinking, that maybe the publication of all the details in the affidavit might be more problematic in terms of whatever investigation the Commission must still do in relation to that affidavit compared to a summary. That's what is in my mind.
Well, let me start by saying the one thing BAIN would not want to do is undermine the workings of this commission. So the whole reason why it wrote the letter to you, Chair, was out of respect to the workings of the commission. So if, Chair, your view is that the mischief at which regulation, the mischief at which regulation 11.3a is directed, if you're of the view that it would produce the mischief that is sought to be averted if the entire BAIN affidavit were to be released, then of course BAIN and Company would respect that. But Chair, with respect, BAIN and Company can't be in a worse position than if it had not submitted an affidavit to this commission. So if BAIN and Company had never submitted an affidavit to the Commission, there would be nothing to prohibit it issuing anything it wanted into the public domain in response to what Mr. Williams said. And so with respect, Chair, it would be completely unfair for BAIN and Company to be worse off because it's gone on affidavit to you than if it had never submitted an affidavit to you. And so, Chair, it does seem at a bare minimum what BAIN and Company must be able to do is to respond publicly if asked. The difficulty for BAIN is on your prima facie reading, Chair, of Regulation 11.3a, it can't quote even a portion of its affidavit. It would have to give what is really a summary of that affidavit. And I believe what you're positing to me, Chair, is, well, wouldn't that be enough as a matter of fairness to BAIN? And Chair, my response is, again, with respect, it's certainly better than nothing. With respect, we would have thought it's simply much better for BAIN and Company to say, here's the version on affidavit, rather than for BAIN and Company to try and summarize what it said on affidavit. But I come back to my original response to your question, Chair. BAIN and Company would respectfully ask for permission to release the entire affidavit. If your view is that that would produce a mischief that the regulation is designed to prohibit, then at a bare minimum, BAIN and Company would require your permission, Chair, to release a summary of that affidavit. It would release that to whoever it wishes to release it to. It may be asked by a client, it may be asked by a media representative. We don't ask for the Commission to assist us in how we publish it. We simply do seek your permission that we may publish it in some or other form if we were to be asked.
Yeah, you see, part of what I have to look at is what the effect would be if in every case where a witness is about to testify, those implicated by the witness are allowed to publish their affidavits in response. It seems to me that we may as well not have this regulation. As I see it, the regulation seeks to say, to lay down the norm, to say the norm is don't publish. But the chairperson is given the authority to depart from that norm and provide written permission. And one would say there needs to be something special in order for the chairperson to authorize a departure from the norm. Because otherwise, if there is nothing special and the chairperson authorizes a departure from the norm, tomorrow there's going to be another person who is implicated by tomorrow's witness who says, I also want to publish my affidavit in response. The following day, another one. And because there is nothing special that needs to be shown, then the publication becomes of affidavits of implicated persons when the witness testifying is, the witness implicating them is testifying becomes the norm. Then you may as well not have the regulation. So that seems to me that's something that I have to reflect on as well. What do you say to that? And when I look at the letter, as I said, it doesn't seem to me that it pleads any special case. It simply says Mr. Williams makes very serious allegations against BAIN. All kinds of witnesses come here every day and make serious allegations against people. You know, so I don't see anything that puts BAIN's case outside of the normal. What do you say about that approach?
Yes, no, thank you, Chair. I'm grateful for the question. Chair, we would accept that Regulation 11.3 has an escape valve which requires you to exercise your discretion on an ad hoc basis. In other words, Chair, it contains the general prohibition, but then says the chairperson can give permission which releases the affected person from the ambit of the restraint. So in our respectful submission, you would have to consider every case on an individual basis and consider whether an appropriate case has been made. If you were to give permission to BAIN, Chair, I understand your concern to be, but then what does the Chair do tomorrow or on Wednesday if another person applies? But with respect, the answer is you would be exercising your discretion on an individual basis and it would have no precedential effect going forward. So the case made out by BAIN in the letter is simply this. It's gone on affidavit. It doesn't know when that application is going to be heard. And very, very serious things are said by Mr. Williams regarding BAIN and Company. Chair, I do hear what you say. You say, well, very often serious things are said by implicated parties in your proceedings. But Chair, you would have to read Mr. Williams' affidavit carefully. Consider that BAIN and Company is still a trading company. In other words, it's a company which is still working with customers. And you would then have to consider whether a proper case has been made out. And Chair, may I also, with respect, suggest that the other thing that the Chair should take into consideration is this. It would, in our respectful submission, be perverse if you were better off not filing an affidavit before the Commission in terms of responding to what someone were to say about you. If you don't submit an affidavit to the Commission, well, then there's nothing to stop you saying whatever you want when that person says things about you in proceedings before the Commission. Here, what BAIN and Company has done entirely properly is it read the affidavit, Mr. Williams, it put up 2 affidavits in response. It would be unfair for BAIN to be in a worse position because it's gone on affidavit. And with respect, that may well be one of the outcomes if the discretion were to be exercised in a way that is not favorable to BAIN. BAIN and Company may then have been in a better position by not going on affidavit. And with respect, that wouldn't be a sensible outcome.
Yeah, no,
I
hear your point about that, and I'll hear what Mr. Franklin has to say about it. It may well be that the approach is, well, those implicated parties who want to operate within the regulations will not go outside of the regulations. They will say, if my case is no different from everyone else who gets implicated, that means I can't apply for or I can't get written permission to for a departure from the norm. But if my case is special, then I will apply, and if the chairperson is persuaded that my case is special, there will be a departure from the norm. And then, of course, there may be parties who decide to operate outside of the regulations and do their own thing, you know, and say, well, we'll just publish, you know, we will not submit affidavits, and will publish outside of the regulations. Or they might say, well, we'll publish first and then submit to the commission, because then if we do it that way, we are not in breach of the regulation. So I'm saying, I hear the point you make, but of course I think you also accept the difficulty that the case made out for written permission there must be something special, to say the least, about the circumstances of the case, because if it falls within the norm, the cases that happen here, if it simply says the witness has made serious allegations against me, allegations of impropriety, corruption, and what. Allegations of corruption and impropriety get made by witnesses in the commission every day. So if that is enough for me to authorize to provide written permission, then I'm going to have to provide it all the time. And then we may as well not have the regulation. But I do appreciate that that's a point I have made, I have put to you, and you have addressed it. So maybe I should let you say what you might need to say before I allow whatever else you might need to say before I allow Mr. Franklin to respond, if there is still anything you would like to say.
Okay, may I just make 2 points in response to what you've put to me? The one is this, Chair, as I said earlier, the whole point of Bain and Company writing to you was in order to be respectful towards the workings of the Commission. So we are especially mindful when you put to us, but the mischief at which Regulation 11.3a is directed may be undermined if parties were given license to release their affidavits before the evidence is in fact given. So we hear what you say, and we're respectful of that, but may I simply say it's not obvious to us how the mischief would be undermined. A party comes before you, a party submits an affidavit to you. The party doesn't know when its application, in this case for leave to cross-examine, will be heard, and doesn't know what the outcome would be. Chair, with respect, it's not obvious to us how the workings of the Commission would be undermined if that party were to be given leave to release its affidavit. And Chair, it ties in with my second point. It's about the time lag between when the evidence implicating the person is given and when, in due course, the subsequent evidence is given. In this case, Chair, we simply don't know when Bain and Company's application will be heard. We don't know what the outcome will be, and if permission were to be given to cross-examine, we don't know when that cross-examination is going to happen. But it could be a long delay, Chair, and so when you say to me, well, should there not be extraordinary circumstances for me, the Chair, to exercise my permission under Regulation 11.3a, the other thing we would respectfully draw your attention to is the uncertainty regarding how long it will take before Mr. Williams is cross-examined, if he is ever cross-examined at all, Chair. But Chair, those are the only 2 additional points I would make. I do believe that I've responded to all of the submissions. I've responded to all of your questions as best I can, Chair.
Yes, that's fine. Let me say that Mr. Bain's application for leave to cross-examine Mr. Williams can be dealt with What I don't know is whether all the affidavits are in, whether any responses and so on, but it can be dealt with. Oh yes, I think there are. There's a response from Mr. Athol. I can see that. And I see it's towards the end. I take it that if there is no replying affidavit from BAIN, it means it has elected not to reply. Is that correct, Mr. Cochrane?
Well, with respect, it's too early. So we received Mr. Williams' affidavit. It was round about 5 o'clock on Friday, as I recall. If my memory is playing up, I'm sure my learned friend will correct me. But my recollection was it was on Friday evening.
Yes.
And Chair, we haven't yet had an opportunity to study it and to make a decision regarding whether BAIN and Company will be filing a replying affidavit.
Yes.
That's not a decision that's been made, Chair. My client hasn't had enough time to study the answering affidavit.
Well, I want to say that the application could possibly be dealt with at some stage even this week. So I think the sooner you make a decision whether you want to file a replying affidavit or not, the better. But if it's not had this week, I'm sure we can. I can allocate time for it next week. So that is one. Two. The undermining, I just mentioned it now, I thought would be if I grant BAIN's application to publish the affidavit, its affidavit, when Mr. Williams testifies or when he has finished, and BAIN's case is no different from every other case, then the undermining would be that if I am to be consistent, I would have then to grant written permission in every case that simply falls within the normal case under the regulations. And that means the affidavits could be published and in their entirety. And of course, if the idea that publication of material submitted to the Commission for investigation may be prejudicial to the investigations of the Commission, then once we have that regime, then that undermines the work of the Commission, because then it's as if the regulation prohibiting publication is not there. You understand?
No, sorry, Chair, I do understand. And Chair,
yes.
Perhaps that's where, with respect, we're missing each other.
Yeah.
I do understand the proposition you put to me. You say, well, if there's nothing special about that case, wouldn't I, the Chair, have to give permission on all future occasions? Mm-hmm. And then you say, wouldn't that prejudice the workings of the Commission? And the only query I raised is, Chair, even if that were correct, let's assume for the sake of argument that in most cases you would then give written permission under Regulation 11(3)A. It's not obvious to us why that would prejudice the workings of the Commission, because these are people who filed affidavits before you, and all that they're asking permission to do is to release into the public domain what they have said on affidavit before you. And with respect to the proposition that that would undermine the working of the Commission is not clear. Chair, we fully understand if someone were to leak an affidavit that she or he was not the author of, there we fully understand that would indeed prejudice the workings of the Commission.
But the disclosure...
What is so different here, Chair, is it's the author of the affidavit who's asking for permission to release the affidavit.
But the disclosure of
and so, Chair,
information while investigations are going on, could be prejudicial to the investigation, isn't it? The disclosure of information on matters that are still being investigated could be prejudicial to the investigation, isn't it?
With respect, I can only say it's not obvious why that could be prejudicial. Because what is being disclosed is what the person has said on affidavit. It's his or her evidence.
Yes, okay, thank you.
So, Chair, the issue you are grappling with, and if you may I just say, we do fully understand why you're grappling with it. You say, well, Regulation 11.3a gives me, the Chair, a wide discretion. How do I exercise my discretion? And Chair, the one response which I should give, which I think I submitted it earlier, but let me say it again. You may well take a different view where someone comes before you and asks for permission under Regulation 11.3a to release an affidavit or some other evidence that he or she is not the author of. But Chair, in this case, what makes the case extraordinary with respect is it's Bain and Company saying, I want to release my own affidavit. And so, Chair, you say, but then wouldn't I always have to give my permission under Regulation 11.3a? Well, it may well be where a party comes before you and says, I want to release my own affidavit. But Chair, that would not say anything about the much more difficult case, which is where someone comes before you and says, I want permission to release some evidence of which I am not the author. And you may well approach that in a completely different way, Chair.
Yeah.
And the only submission we're trying to make, and let me snapshot it, is the concern you have that it may create a precedential effect where a party wants to release its own affidavit. The concern is, Chair, you put to me, wouldn't that prejudice the workings of the Commission? And our response is, it's not obvious how it could prejudice the workings of the Commission because it's simply a version on affidavit by that person regarding what he or she did or what he or she says in response to someone else's affidavit. The version may turn out to be wrong, or it may turn out to be wrong. With respect, if it's wrong, it's always going to be wrong. Merely releasing into the public domain an affidavit that may turn out to be wrong, it's not going to prejudice the workings of the Commission or respectful submission. And so, Chair, it comes before the T adjournment. Regulation 11.3a may not even apply on one interpretation. I put it no higher than that. It may not even apply where a person seeks permission to release his or her own affidavit. But if it does apply, and what you put to me, Chair, is that's your prima facie interpretation, if it does apply, then in our respectful submission, there would be no prejudicial consequence of this Chair saying, well, it does apply, but I will take a more generous view when it comes to exercising my discretion under 11.3a, when you are the author of the affidavit, than if someone else comes before me seeking permission. In other words, there would in effect be two categories. One where you are the author of the affidavit, and a second category where you aren't the author of the affidavit. And Chair, you may well approach those in completely separate ways. But the concern you have that it would undermine the workings of the Commission, if you were to have a general rule that you are prohibited from releasing your own affidavit in advance. In our respectful submission, it's not obvious to us how that would prejudice the workings of the Commission.
Okay, the other thing which I almost forgot to raise with you is I see that BAIN, in its application, while applying for leave to cross-examine Mr. Williams, did not apply for leave, as I read it, unless I've missed it, for leave to adduce evidence itself and subject itself to questioning by the evidence leaders and the chairperson. Is there any particular reason why?
That is not part of the affidavit. That is not part of the affidavit.
Is there any particular reason why?
That is not part of BAIN's application, Chair.
Yeah, so why is that? Do you know, or is that something you have no instructions on? You know, it's important because...
No, Chair, I don't have any instructions on that. I can only...
Yes. Let me mention it to you. Let me mention to you.
Well,
Let me mention this. If BAIN, for example, had applied for leave to cross-examine, not for leave to adduce evidence or give evidence, it may well be that arrangements could have been made that whoever was going to give evidence from BAIN would have been accommodated this week so that BAIN could, within a few days of Mr. Williams giving evidence, have the opportunity of also putting up its side of the story before the hearing. That's a possibility, but also if somebody wishes to cross-examine whoever implicates them, it may well be that is the right thing for them to subject themselves to questioning by the Commission. So I mentioned that simply because I noticed that there is only an application for leave to cross-examine. But also, I must mention to you that something has crossed my mind with regard to BAIN in relation to the Nugent Commission. I haven't gone back to that report for some time, but the Nugent Commission report, but I did read it at a certain stage. And I recall that, if I recall correctly, somebody who was testifying on behalf of BAIN did not complete his evidence before the Nugent Commission. And the reason that was apparently advanced was that he was sick or something, I can't remember, but my recollection is that Judge Nugent didn't seem to buy that story. And I certainly left with the impression after reading the report that BAIN had decided not to cooperate with the Nugent Commission and not to complete its evidence and subject itself to questioning in the Commission. Now, when I see that it doesn't apply for leave to adduce evidence in this Commission, but applies for leave to cross-examine Mr. Williams, I wonder whether they are prepared to submit themselves to questioning by this Commission, or whether they just want to cross-examine and make written submissions and not subject themselves to questioning by this Commission. You might not be able to say anything about this, but I'm just raising it with you because it has crossed my mind.
Well, Chair, those are all very important questions, and let me respond to them, and let me tell you what's on the record. So when you ask me what is the reason for something not being in the BAIN application, that's obviously not something that I can deal with. I can only tell you what is in the application.
Yes.
Asked for leave to cross-examine, it asked for leave to make submissions. It doesn't seek leave to give evidence before this commission. Chair, number 2, on the record, that point has been taken by Mr. Williams in the affidavit he filed on Friday. I think I'm summarizing it fairly enough when I say that's one of the points taken by Mr. Williams. He says, well, Bain and Company shouldn't be entitled to cross-examine him if they are not tendering a witness. Now, Chair, that's a fight for another occasion. We'll have to have that fight when we move our application for leave to cross-examine in due course. What I do tell you is that at the moment, that is not part of the Bain and Company application. Chair, what you refer to in the report of the Nugent inquiry, I believe that's Mr. Masoni. Chair, Mr. Masoni was said in Mr. Williams' statement. As I understand it, Chair, Mr. Masoni is separately represented because he is no longer an employee of Bain and Company. And so my understanding, and if I'm wrong, I'm sure one of my learned friends will correct me in due course, but my understanding is he is separately represented. Certainly I don't hold a brief for Mr. Masoni, Chair. I hold a brief for Bain and Company South Africa, and they no longer employ Mr. Masoni. So, Chair, the evidence you refer to before Nugent and the finding of Judge Nugent that Bain and Company didn't cooperate fully, that indeed is something referred to by Mr. Williams in his affidavit, and it's also referred to in the affidavit by Mr. Min that serves before you, Chair. There's a version in Mr. Min's affidavit in response to that. But Chair, where all of this goes is the point you put to me is, does Bain and Company seek leave to give evidence before you? And the answer is no.
And then the next question is it prepared to submit itself to questioning by the Commission, if the Commission wants them to do that?
Well, Chair, that is something I would have to take instructions on. I'm just not in a position to answer that question.
No.
I fully understand the point of the question.
Yes.
As I sit here today, I'm not in a position to give an answer to that question.
No, that's fair enough.
That is something my client would have to consider, and that's something I would have to consider.
Yes, no, that's fair enough. Mr. Franklin, maybe I should take the tea break and then let you address me after that.
As you please, Chair.
Yes, we are at 26 minutes past 11. We will resume at 25 to 12. We adjourn.
Chair.
Yes,
So
okay.
if I may hand back to him before I reply.
Yes, okay, all right. Yes, Mr. Cockrell.
Thank you. Thank you, Chair. Thank you to you, and I'm going to my learned friend. Chair, let me see if I can perhaps expedite this. Chair, in response to your question, could my client live with a summary rather than publishing the full affidavit? The response I gave to you is in some ways that may make my client's life more difficult because it would have to give a summary that doesn't reproduce parts of the affidavit. But having said that, Chair, I've taken an instruction during the adjournment, and my client's attitude now is it does indeed ask for permission to publish a summary of the affidavit. It no longer applies for permission to publish the full affidavit. And Chair, I said repeatedly in my address to you, my client wouldn't want to do anything that is undermining of the work of this commission. The proposition you put to me is it may undermine the work of the commission if the full affidavit were to be published in these circumstances. And that is why my client now simply seeks your permission to publish a summary of the affidavit and not the full affidavit, Chair.
Okay, all right, thank you. Mr. Franklin.
Thank you, Chair. If I may respond briefly to the two topics that have been addressed by my learned friend. The first concerns the question of privilege. As he made clear, we no longer seek a ruling in that regard because of the accommodation that has been reached. But BAIN has nonetheless placed on record that it does still assert privilege over the identified documents. If I may briefly respond to that, simply to put on record for purposes of the Commission a denial that there is in fact privilege that attaches to any of those documents. As the evidence will reveal, Mr. Williams was appointed in a special role to oversee an investigation which BAIN initiated into its own conduct, and the repeated refrain was that it wished to play open cards, reveal the truth and do right for South Africa. And so we don't understand how it can simultaneously make that assertion and then when it comes to revealing documents which are the product of that investigation to claim privilege over them. In any event, all of the documents that are sought to be introduced were given to Mr. Williams pursuant to his mandate. So we simply place that on record, that in our view, there is no proper claim of privilege. Secondly, in relation to the letter and the request that BAIN be given permission to publish its affidavits, or now it seems a summary. For the purposes of the record, may I just identify the BAIN letter from Baker McKenzie, dated 26 November 2020. It's found in SARS Bundle 02, Exhibit WW5, which is the correspondence bundle, at page 93. Our submission is this: Regulation 11.3a, we would submit, does deal with this situation. It regulates this situation. It says that no person shall, without the written permission of the chairperson, disseminate any document submitted to the Commission by any person in connection with the inquiry, or publish the contents or any portion of the contents of such document. That, with respect, covers the situation that BAIN finds itself in, where it has brought an application to cross-examine, and it has, in support of that, attached a number of affidavits. So we would submit that, with respect, the Chair's prima facie view is correct, that Regulation 3.3a governs the situation. The upshot of that is, of course, that it is within the Chair's discretion to grant the permission which has been sought or not. And we would submit that there are a number of compelling reasons why that permission should be refused. The first is that the mandate of the Commission is, of course, to investigate matters of public and national interest concerning allegations of state capture, corruption, and fraud. So, by its very nature, that is the subject matter of the evidence which the Chair has heard for months on end. So there's nothing particularly unique about the evidence that is being introduced which implicates BAIN. Secondly, we would submit that granting the request would result in BAIN not being treated equally with other parties who have been implicated in matters placed before the Commission. That's a central feature which we ask the Commission to take into account. And what would happen, we would submit, is that one would have a situation where all 2,700, I'm told is the number, implicated persons would then regard themselves as also entitled to ask the same relief. And if one looks at the BAIN situation, there's nothing unique in the grounds that are set out in its letter. All it asks for is a right to publish in order for it to be treated fairly. Every implicated person could mount exactly the same argument. And so one has a difficulty in granting what should be an exceptional remedy in circumstances where the circumstances are not exceptional. Secondly, we would submit that publication of the affidavits would defeat the purpose of its application to cross-examine Mr. Williams in any event. It is perfectly entitled to publicize, if it so wishes, in answer to any query that might be raised. Yes, we've heard the evidence given by Mr. Williams, but we want to let you know that we've applied to the chairperson to cross-examine, and his evidence will be tested in due course if we are granted permission. That's a perfectly adequate safeguard for addressing the concern which they have. And really it comes down to this, Chair. My learned friend articulates why there is a difficulty for BAIN not to get permission. And my answer to that is that the difficulty is faced by everyone before the Commission, equally. So we would submit that the upshot is that practically one would need to depart from the norm in all cases because these facts are not unique. We also, with respect, believe that the point raised by the Chair is very significant because what BAIN wants is to blunt the import of Mr. Williams's testimony with affidavits of its own in circumstances where it is not prepared to put up any witness who will himself or herself be subjected to cross-examination. That is a case of having one's cake and eating it. And where fairness is called in aid, we would submit that it would be blatantly unfair for that situation to be allowed. Our learned friends have said that a summary would suffice. And as I understand it, it would be a publication of a summary of the contents of the affidavits which currently serve before the Commission as part of BAIN's application. And that via media, whilst it may sound attractive, we submit falls foul of precisely the same considerations which I have set out, because all it is a shorter version of the evidence which is sought to be put up. And for the same reasons that I have articulated, we would submit that that would be inappropriate. So the principle is either permission is granted or not. It doesn't ameliorate the factors which I have outlined in opposition to the grant of the permission by saying we are content with a shorter summary. So in conclusion on this, we submit that BAIN is attempting to secure for itself a right which no other party has sought or been granted, that there is certainly no proper basis upon which the Chair can grant that permission, and we would ask that the Chair refuse the permission. Thank you.
Thank you. Mr. Cockrell, would you like to respond to that?
Let me respond very briefly. My little friend's first submission is he says that BAIN will not be treated equally because other implicated parties, as I understood it, haven't applied to be placed in the same position. Chair, I searched through your website this morning. I'm not aware of any implicated party who has sought permission under Regulation 11.3a. So with respect, the fact that BAIN is the first party to do so is a point in its favor. So with respect, Chair, we simply don't understand the submission that BAIN is seeking to be treated in a more favorable way than other parties. The bottom line is that BAIN is the only party who has sought your permission under Regulation 11.3a, and that should count in its favor, not against it. My learned friend then said that if BAIN were to be granted permission under Regulation 11.3a, it would defeat the purpose of the application to cross-examine Mr. Williams. With respect, Chair, we simply don't understand the submission. There is an application to cross-examine Mr. Williams. That will be heard in due course. Some of the issues you raised with me, Chair, may become of some importance in that debate. But all that BAIN is seeking permission to do now is to release a summary of the affidavit it has placed before you. And how that would defeat the purpose of the application to cross-examine is simply not apparent to us. Chair, as regards the summary, my learned friend says, well, that is objectionable for the same reasons as the full affidavit. Again, Chair, with respect to our learned friend, we simply don't understand the submission. The one thing you haven't heard a word of from my learned friend, Mr. Franklin, is how would it undermine the workings of the Commission if Bain and Company were to be given permission by you to release a summary of its affidavit? I want to focus on that because that was the fulcrum of the debate you and I had earlier. And your concern was that releasing the full affidavits may undermine the work of the Commission. And now the debate is, would releasing a summary undermine the work of the Commission? And we listened closely to our learned friend. We didn't understand there to be a single submission regarding why the work of the Commission would be undermined. And Chair, with respect, it's completely counterintuitive because what in effect you would be saying to an implicated party is when you are implicated in the evidence, you can't even refer to the affidavit you have placed before the Commission. You can't refer to it by way of a potted summary. You can't refer to it by way of a full summary. In effect, if you are asked to give comment, there is nothing you can say, because any answer you give is likely to anticipate what you have said on affidavit. Our learned friend says, well, you could simply say we've applied for leave to cross-examine, but that's no answer at all, Chair. So with respect, Chair, it does seem to us that the critical issue for you, Chair, would be in what meaningful way would it undermine the work of this Commission if Bain and Company were given permission under Regulation 11.3a to publish a summary of the two affidavits it has placed before you? Chair, I don't know if you've had a chance to read those affidavits. May I say they are very full affidavits. And so, for example, the debate you and I had, Chair, about what Judge Nugent found regarding Mr. Masoni, that is a topic dealt with in one of the affidavits. The two very lengthy affidavits would not be published in their full form in the amended version of what Bain and Company now seeks. All they ask for is permission to publish a summary. And with respect, Chair, it would be entirely unfair not to grant that permission to Bain and Company, because in effect you would be muzzling them. You would be muzzling them until some unidentified future time, even when Mr. Williams has given his evidence. And so with respect, Chair, we would continue to ask for the relief in the attenuated form in which my client now asks for it. All it asks for is your permission under Regulation 11.3a to publish a summary of the two affidavits it has submitted before you. And Chair, with the greatest of respect to our learned friend, there is no meaningful answer to why that permission should not be given. On the contrary, it would be extraordinary if the permission were to be refused, because it would create a most bizarre outcome where an implicated person is unable to say anything about his or her version. So with respect, Chair, we would continue to ask for that relief in the modified form in which I've explained it. Thank you, Chair.
I wonder whether there would any merit in looking at the possible interpretations of the regulation and seeing whether one of them places lesser restrictions on an individual's right compared to another one, and whether there may be an interpretation, whether the correct interpretation may well be one, whether it may well be one which allows that. Now, I'm going back, I know we dealt with this earlier to say which is the correct interpretation. In terms of the one interpretation, which was the one I was inclined, towards which I was inclined, was to say the regulation means anybody. Nobody is permitted, including a deponent to an affidavit, to publish a document that has been submitted to the Commission without the written permission of the chairperson. The other one being, well, if it's your deponent, if it's your affidavit, maybe the regulation doesn't cover that. It's only if you seek to publish somebody else's document or another document, or but of course there was the issue that I raised to say we need to look at what mischief was sought to be prevented from happening. So that there is that. But you made the point that whichever interpretation you believe you should apply for leave, and that's why that's the approach you have adopted. Do you want to say anything on this?
I just want to make this submission, Chair. Even if the interpretation were to be adopted, which said Regulation 11.3a doesn't stop BAIN from publishing its own affidavit, the difficulty BAIN would still have is the BAIN affidavit referred to Mr. Williams' affidavit. Okay. And that's why I said on any version, you would require your permission under 11.3a. In other words, even if the narrow interpretation were to be adopted, there would still be a problem because the BAIN affidavit to Mr. Williams' affidavit. That's the point I made.
I guess one of the serious difficulties is simply that there seems to be nothing special in BAIN's circumstances compared to the norm. But you have addressed that, we have dealt with that. Let me hear Mr. Franklin. Yes. Yes, you want to say something on that?
It's difficult for me because I have had some involvement with the Commission over the years, but I'm not steeped in the way in which you function. So I simply don't know the sorts of applications you have had before you. But may I simply say, the application by Bain and Company contains two very substantial affidavits. So I don't know, Chair, whether that is the norm of the sorts of affidavits you have before you, but I would be surprised, quite frankly, if any other applications before you had affidavits of that length. So if you say what is different about the Bain affidavits, or the Bain application, Bain and Company puts two affidavits before you containing a detailed narrative. It says, I want permission, I want your leave to cross-examine. The difficulty, Chair, is unless the permission were to be given to Bain to publish a summary of those two affidavits, it would be very difficult for it to say anything meaningful. If it were asked by a media representative or by a client, what is your response to Mr. Williams' evidence? That just seems so unfair. So when you say what is special about Bain, we would say, firstly, would you have regard to the length of the affidavit and the level of detail in that? And then secondly, would you consider the position of BAIN if it were by a client or by a journalist? What answer could they give unless they were given your permission in order to publish a summary of those two very detailed affidavits?
Yes. Mr. Franklin, do you want to deal with the issue I raised? And I just want to also say, to a certain extent, is it not correct that there is some unfairness, or there may be some unfairness if somebody says all kinds of things about you and you are not able to respond and put your side of the story?
Yes, thank you, Chair.
And if there is or may be unfairness, the next question may be whether that's the unfairness that attaches to the regulations as they stand, and as long as they stand, that's it, as opposed to...
It must cover any person. That would include BAIN within its purview. That must be clear. If that is so, then you are given a discretion as chair to give permission or not. So we're back to where we were. As far as the potential for unfairness which you have raised is concerned, we submit that there is none because of the scheme of the rules and the regulation with which the chair is very familiar. And it runs along these lines. The Commission calls a witness. If the witness implicates parties A, B, and C in wrongdoing, then the Commission is required to issue a Rule 3.3 notice to those implicated persons. They are then put on notice that allegations of impropriety have been levelled against them. If they fall into that category, they are then accorded certain rights. Those rights are to apply for cross-examination of the accuser and or to apply to lead evidence themselves or present evidence themselves. So that addresses the Audi alteram partiam issue. It addresses a situation which would otherwise be unfair, where an accuser is entitled to say what he or she likes about a person with impunity. They have to understand that if they implicate somebody, they may be cross-examined by that person on the evidence which is put forward. And also that person may be allowed by the Commission to him or herself give evidence. That scheme is perfectly fair. It accords the usual rights which we all understand in the legal practice. We would submit there's no room for a via media, and especially one in respect of a party who has seen fit not to present evidence himself or herself, and more importantly, to subject themselves to cross-examination. What BAIN wants is to try to blunt the testimony of Mr. Williams by way of publishing of affidavits without simultaneously asking for the deponents to those affidavits to come before this Commission to give that evidence and to be cross-examined. That is unfair. So we would submit, in answer to the points raised by the Chair, that the construct of the rules is perfectly fair. It builds in the safeguards that one would want to see. And what is being asked for here is not something which should be granted because there are adequate rights which exist for BAIN in any event. And we would also contend that it would be not a salutary practice for implicated parties to adopt this same procedure. So we certainly do persist with the opposition to the publication.
So, just to summarize your points or your approach, you say the Commission operates within the framework of, obviously, the Constitution, the Commissions Act, the regulations, and the rules. and you say that framework makes provision for fairness to happen in a certain way, and that means if you are implicated by a witness, you get given a Rule 33 notice. That's part of the Audi rule, and that's part of fairness. You are then given an opportunity to apply for leave to adduce evidence, to cross-examine, and to call any other witness you wish to call, so as to put your side of the story. And that framework may well mean, when one reads the relevant regulation and other parts of, and other regulations, may well mean that your side of the story, you are not able to tell your side of the story at the time that you would prefer. But you will be given a chance to tell your story, particularly if you wish to and you comply with the regulations and the rules. In other words, you apply for leave to adduce your evidence, and if you want leave to cross-examine, you do that. You will get that chance. And unless your case is exceptional, there is no ground to seek to find fairness outside of that framework.
With respect, the Chair has summarized my points more than adequately.
Yeah. Okay. Okay. No,
Thank you.
Thank you. Mr. Cockrell, what you wanted, if I were to grant you leave or the written permission, would be for your client to publish the summary at least at the same time as when Mr. Williams' affidavit gets made public by the Commission. Is that right? Or did you want to publish it while Mr. Williams was still continuing with his evidence? I didn't think it would be the latter.
Chair, in the letter to you, the letter to you, Chair, the letter to you seeks permission to publish what would now be a summary at the moment when Mr. Williams commences his evidence. But if you would regard that as being prejudicial, you would then fix a more appropriate time frame at which my client can release the summary. In other words, if you wish it to be later on, we would be in your hands in that regard. But the letter seeks permission to publish what would now be a summary at the time when Mr. Williams commences his evidence.
Well, part of the reason why I was asking is that I was thinking that maybe I could give my decision tomorrow morning. I think Mr. Williams is likely to take the whole day. Well, we already have taken half a day. Would that be fine with you?
Chair, I would need to I'm reluctant to say it would be fine with me because I would need to take an instruction in that regard. If you can just bear with me for a few seconds. May I just check the phone? Chair, I'm sitting in Cape Town. I apologize, and my attorney's in Johannesburg.
Oh, okay, all right. Are we going to need to adjourn for you to take instructions or not?
No, there should be no need, Chair. If you can just bear with me for
yeah, okay.
You can just bear with me for a minute or two, Chair.
Okay, all right.
Yes, Chair. Chair,
Yes.
thank you for the indulgence, Chair. My instruction is, if the Chair is able to rule on that tomorrow, that would be acceptable to my client. Chair, may I simply say this so that the point isn't lost in the wash? The submission made by the Commission with respect to them is really quite extraordinary. Because if you consider what it means, assume my client in due course is refused leave to cross-examine. Well, on the Commission's logic, it means my client can never release its affidavit, and in fact can never even release a summary of its affidavit. In other words, will never be able to give its version in response to Mr. Williams in the public domain. It is a most astonishing contention, but that is the logic of what the Commission is saying to you. They are saying there's a period during which my client can say nothing. That period may come to an end, but if it doesn't come to an end, my client is in effect muzzled in perpetuity. Well, Chair, it is a most extraordinary proposition. And Chair, what you said at the commencement of the address after the adjournment is, well, wouldn't one have to consider the different competing rights that are relevant when one interprets Regulation 11.3a? Well, Chair, the right to freedom of expression is the obvious one that is relevant, because this is my client, but its version happens to be one it's put up in affidavit before you. What the Commission is saying is, for a period of time and potentially in perpetuity, my client cannot give its version in the public domain. With respect, Chair, that is an extraordinary attitude to be taken, and we submit that it is not a submission that has any merit whatsoever. But Chair, subject to all of that, Chair, we would respectfully ask you to rule on that, and we do understand that you will rule on that tomorrow morning.
Yes, yes, no, I will do that tomorrow morning, but I've given you this further bite at the cherry. I just wonder whether Mr. Franklin wants to say something about this last point that you have emphasized.
Chair, I've made my submissions with respect. That is the construct of the rules, and no doubt it contemplates that an appropriate decision will be made in relation to the requests for leave to cross-examine or to present evidence.
Yes, okay, all right. Then I'll give my decision tomorrow morning.
As you
Okay,
please.
thank you. Are you ready to call Mr. Williams, or you need a few minutes to?
No, we would wish to call him if we could.
Yeah, let's
Thank
do
you.
that. Yeah, you may go ahead. You may administer the oath of affirmation.
Please state your full names for the record.
Athol Williams?
Do you have any objection to making the prescribed affirmation?
No.
Do you... Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you. Thank you, Mr. Williams, for availing yourself to come and assist the Commission.
Thank you, Chair.
Thank you. Mr. Franklin.
Thank you, Chair. Good morning, Mr. Williams.
Morning.
You have a bundle before you, which is marked SARS Bundle 01. You have that?
That's correct, I do.
Please turn to the paginated page on the left-hand side, that is SARS 01011, page 11. You have that?
I'm there.
You see that is a start of an affidavit in your name. Please turn to page 119 of the same bundle.
I've got it.
you see that there is a date, 20 August 2020, and a signature. Can you confirm that this document from page 11 to page 119 of SARS-01 is an affidavit attested to you by you on the 20th of August 2020?
That's correct, Chair, it is.
And can you confirm the truth and accuracy of that affidavit?
I can, yes.
Thank you, Chair. I would ask that the affidavit be admitted as Exhibit WW1.
The affidavit of Mr. Athol Williams, which starts at page 11, will be admitted as an exhibit together with its annexures and will be marked as Exhibit WW1.
As you please, Chair. Mr. Williams, I intend to take you to various parts of this affidavit and its annexures, and we shall do so topic by topic. I will ask you to answer my questions in relation to specific issues which are put before you. If we could start, please, with your qualifications and experience. You deal with it at paragraph 14, page 17 of the affidavit. In each instance, I am referring to the page number in SARS Bundle 01. And if I change bundle, I will, of course, tell you. Please go to paragraph 14. You have that?
I'm there.
Can you confirm that you have a bachelor's degree in mechanical engineering from Wits University, a master's MBA from the Massachusetts Institute of Technology, a master's degree MSc in finance from the London Business School, a master's degree MPA from Harvard University in the United States, a master's degree MSc in political theory from the London School of Economics.
I'm sorry, Mr. Franklin, from what page are you reading?
Page 17.
Page 17.
Paragraph 14, Chair.
Oh. Yes, okay, thank you.
Thank you. I was busy outlining the various degrees that Mr. Williams has. The penultimate one is a master's degree, MPhil, in political theory from Oxford University. You confirm that that's correct?
That's correct.
And is it correct that you are presently busy with a doctorate degree, which is a DPhil from Oxford University as well?
That's correct, Chair.
How many master's degrees have you got, Mr. Williams? Is it 4 or 5?
5.
Sure.
I clearly need more hobbies, Chair.
No, that's very commendable. That's very commendable. Yes.
I think that's relevant to part of the role I was called to play at BAIN. Was a lot of my background was in business.
Yes.
The first 3 degrees qualified me in business. The last 3 in ethics, applied ethics and corporate ethics.
Yes.
So I basically retrained myself midway through.
Yes. Thank you.
Thank you, Chair. Then if I could deal briefly with your career at BAIN. We're, of course, interested in the latter part, but would you look at paragraph 21 on page 18?
Yes, I've got that.
I must just say on a light note, Mr. Williams, that you can't have so many master's degrees and not complete the doctorate, so you have to complete the doctorate.
I'm trying, Chair.
Okay, Mr. Franklin.
Thank you, Chair. If I could run through this, which I doubt will be controversial. You first joined BAIN in 1995 as a summer associate or intern, as is generally known. Is that correct?
That's correct, Chair.
And then thereafter you had 3 periods of full-time employment, 1996 to 1997 in Boston, 1999 to 2001 in London and Boston, with extended periods in New York, and then 2009 to 2010 in Johannesburg.
That's correct, Chair.
Is that correct? Let us jump forward to your time in Johannesburg, which you deal with in paragraph 24, page 19 of the statement. You joined BAIN as a partner in September 2009 in Johannesburg after they approached you with an offer. They were restarting their South African operation after having left the country in 2002. Then could you just explain, please, when you worked for that period, September 2009 to 10 in Johannesburg, what was the setup at that office? Who was in charge and who were your colleagues?
So when it started in late 2009, there were very few of us. There were 2 partners and 1 part-time partner. And the idea was we were going to need to have a managing partner, a boss, essentially. And so for 2009, we kind of just got the office going a bit. But in early 2010, the managing partner arrived. And this was Mr. Vittorio Massone. So he arrived from Italy as the head of the South African business.
That's Mr. Massone, M-A-S-S-O-N-E.
That's correct.
He is the man who gave testimony before the Nugent Commission.
That's correct, Chair.
All right. Was there also a Mr. Moulman at the office at that time?
That's correct. So myself and Mr. Moulman were the 2 South African partners, and then Mr. Massone came and he was the 3rd partner then.
Right. In paragraph 25, you have set out certain concerns which you had at that time regarding Mr. Massone. Could you summarize them for the Chair?
So, Chair, very early on in 2010, after Mr. Massone arrived, in fact, myself, Mr. Moulman, and some of the other senior people in the office began to be concerned about the way Mr. Massone was behaving towards clients, the way he was interacting with other people. Concerned enough that we contacted, myself and Mr. Moulman, contacted the London office, the South African office at that point, reported into London. We were so concerned about whether this person, Mr. Massone, was the appropriate person to lead this business based on his behavior, that we contacted the London office and asked them to come and investigate what was happening in South Africa. And some of the things that were happening was, I personally doubted Mr. Massone's ethics. I doubted whether he was honest. I doubted whether you could trust what he was saying. I got to a point where one of my clients said to me, if you bring that person along again, Athol, we won't speak to you. Mr. Massone was shouting at people in the office. And so we didn't feel, as the evidence leader suggested, my career with BAIN started in 1995. So as a career BAIN consultant, I knew the culture BAIN fostered and the way we interacted with our clients and our people. And we didn't feel that Mr. Massone represented that. So we asked the head of the London office to come and investigate. He then came to Johannesburg, and we were convinced that Mr. Massone was going to be relieved of his duties, but he wasn't. And so the way we interpreted that was, it was BAIN Global basically endorsing Mr. Massone's behavior. We had told him our concerns. They still kept him in that position. So much so that pretty soon after that, I chose to leave the business on those grounds.
Right, and you went to London, as you have said, for a short while. You returned in 2010. Mr. Massone was still in charge of the office.
Yeah.
You then resigned in 2010, and you took on the role of senior advisor on an ad hoc basis.
That's correct, Chair.
All right. You weren't then in permanent employ of BAIN for the period from 2010 until 2018. Is that correct?
That's correct. I wasn't a permanent employee ever again from 2010.
All right. Then, if we could go ahead to 2018. You are aware that the Nugent Commission of Inquiry, as we call it colloquially, was set up in 2018 and took evidence from various parties, including Mr. Massone. You heard the testimony that was given by Mr. Massone?
That's correct.
What was your reaction to it, and what did you do about it?
I was shocked to hear Mr. Massone's evidence, Chair. In a way, given my concerns back in 2010 already, hearing the allegations against BAIN and hearing Mr. Massone's evidence didn't surprise me in a way. In fact, it was my worst fears coming true. because I suspected that he probably wasn't going to be an ethical leader. I left the business, wasn't part of the business, and 8 years later, I saw a manifestation or heard a manifestation of my earliest concerns. Upon hearing his testimony, I then did two things. The one was I wrote an email to Mr. Masoni's boss, effectively, who I hadn't met, but I knew who he was, and expressed my disappointment as a former BAIN partner, someone who was still proudly associated with BAIN, that we had raised the concerns in 2010. They are now materializing in a very negative and damaging way. So I expressed my disappointment. I basically said, in many ways, we're not surprised, but then I did offer my support, still as a loyal BAIN person of long standing, that if there was a way I could help BAIN through this crisis, I would. The second thing I did was to contact an investigative journalist, because I saw there was a journalist writing quite a bit about the Nugent Commission. And so I offered as a BAIN partner, former BAIN partner, that if I could be of any assistance, I would offer that assistance.
Right. Could I ask you to look at Annexure AW7, which is at page 135.
I've got it.
That's an email which you sent to Mr. Moyane dated the 6th of September 2018. Is it correct that you set out there some suggestions as regards the role that you might play?
That's correct, Chair. I had Mr. Masoni's evidence to the Nugent Commission ended at the end of August 2018. A few days after that, Mr. Moyane had sent an email to all ex-BAIN employees, so BAIN alumni. I was included in that. So I got this email from Mr. Moyane saying that they are dealing with this crisis. I then replied to Mr. Moyane with my same disappointment I'd expressed to Mr. Masoni's boss, saying this is just unacceptable. Mr. Moyane called me and we had a phone call. In fact, I think we might have had 2 phone calls. But we had a phone call where he basically said, is there a way I can help them? Given my knowledge of BAIN, my knowledge of management consulting, and my knowledge of ethics, of business ethics, was there a way I could help them? And I said, I'll give that some thought. The next morning, or the same night after that phone call, I set out a few thoughts. And the one thought was around things BAIN could do. Think about whether they need to acknowledge the harm they've caused, whether issue an apology, have some plan around restitution. So some of the very standard things you'd expect of anyone who wanted to make amends for something that they've done wrong. I think importantly, from my standpoint, I express a willingness to get involved in the short term, and I said I'm willing to help, but be very clear what I've called a hierarchy of interest. I wanted to be clear to BAIN that if I was going to help them, it was going to be in the interest of South Africa. And I said, at the bottom of the list for me is BAIN, then myself, then South Africa. So whether there's going to be a conflict or a decision to be made about what was the right thing to do, I wanted them to be clear that if I got involved, my primary interest was doing the right thing for South Africa. And that's the basis on which I engaged.
Right, you referred to a statement to the BAIN team. Please look at AW3, page 125 to 126. Is that the statement that you are referring to?
Page 125.
On the left, top left.
What is the page? Is it 125?
Correct, Chair.
That's correct, Chair. So this was the email that was sent by Mr. Moyane to all of BAIN's alumni.
All right, we'll see different iterations of this as we go on. Then please look at AW4 at page 128. That's an email dated the 4th of September 2018 from you to BAIN Africa alumni, and you addressed it to Mr. Moyane. That's Tian, is that correct?
That's correct.
And just summarizing it, you took issue with his description that BAIN alumni may be deeply uncomfortable, and you said that that trivializes the real impact on BAIN. Is that the message that you conveyed?
That was exactly the message, Chair. The reason I reacted so strongly to this was, as a management consultant, as a business advisor, your reputation is it. And I think it's true in most professions. Your reputation is all you've got. And I staked my reputation hugely on the fact that I was a former BAIN partner. That was what I carried as an element of pride. And so these things that were happening, in my mind, was destroying this asset that I felt I had. And I felt that the statement from BAIN trivialized that damage that all of us as former BAIN employees carried, having been former BAIN employees. And I was a BAIN partner. I was a senior person at BAIN. And so the calls I got from my clients, CEOs in South Africa, saying, Athol, you assured us and give us the impression of BAIN as a company of integrity. Look what's happening now. So I was very disappointed in the way they trivialized the issue.
Yes, please turn to AW5, page 130. That is a response from Mr. Moyane to you dated 5 September 2018 in relation to the press release, correct?
That's correct.
And reading from the third paragraph, what I can assure you is that all current BAIN employees, myself included, are having an even harder time, also through no fault of our own. We are facing an incredibly difficult situation, and we are only now learning some of the real facts. There is a very genuine desire from Manny Maceda, M-A-C-E-D-A, down to the team in SA, left to address this disaster, to do the right thing. Since the real facts started to come out on Friday, I have been pulled into a process to find the right way forward, true to our values.
I'm sorry, Mr. Franklin. You have left me behind.
I'm sorry.
I was still at page 128, but I think you are on another page now.
Yes, 130.
130. Okay.
And Chair, I had read out the third paragraph.
Oh, yes, I see it, yes. Yeah.
Into the record.
Yeah.
Yes, so that was the view expressed by Mr. Moyane to you at that time.
That's correct, Chair.
All right, you've told the Chair that you had offered yourself as a potential consultant, as it were, in order to assist BAIN in the predicament it found itself, correct?
That's correct, Chair.
Please turn to AW8 on page 138.
I've got it.
As I understand it, this was a prelude to an agreement that was concluded.
That's correct.
It's dated the 7th of September 2018. It's an agreement between Bain and Company South Africa and Mr. Athol Williams. Just summarizing again, it sets out an intention to enter into an independent contractor agreement. Amongst the responsibilities you would be given, Williams shall observe Bain's compliance with ethical business practices and professional standards. And then paragraph 5, if I may read that out. If Williams is not satisfied that Bain has acted or intends to act in a manner that will address his concerns, he shall in no way be restricted from bringing his concerns to the attention of an appropriate third party outside of Bain. And Williams shall not be deemed to be in breach of his confidentiality obligations to Bain in such an event. So just pausing there, it speaks for itself, but there appears to be a sentiment expressed between you and Bain that you should be allowed to have access to such information as you wish in order to bring concerns to an appropriate outside party if you believe that was necessary.
That's correct.
And then in paragraph 6, Bain further agrees that in the event of a situation arising under section 5 above, it shall not assert any claim of legal privilege to prevent Williams from bringing his concerns to the attention of an appropriate third party. That the understanding again under which you worked eventually?
That's correct, Chair.
And you have obviously been party to the application that was brought initially for a number of the annexures in your statement to be kept from the public, from public disclosure. What's your comment on that attempt in the light of these two paragraphs?
Chair, my understanding from the discussion I had with Mr. Moyane and with the discussions I had that led to this letter of intent was that Bain really wanted to do the right thing in South Africa. These were not strangers to me. the leadership at BAIN now were all people who started with me 20 odd years ago. So I've known them all for many, many years. And so that just comes with a level of trust. So in my interpretation, something had gone wrong at BAIN and that needed to be dealt with. But now BAIN wanted to make sure the right thing was being done. And the evidence leader mentions Manny Maseda. Manny Maseda was the worldwide managing partner, the worldwide managing partner of BAIN. He himself was saying, we want to do the right thing. And this is even written in capital letters. So my understanding was that I had this open access. I was going to work from inside BAIN, but my reason for being there was not to protect BAIN. My reason there was to make sure we did the right thing for South Africa. And if, for whatever reason, I thought there was a conflict, or I wasn't happy with what BAIN was doing, or how they were conducting themselves, I was free to go to a third party with that concern. So when I see an application that then says the materials that I've gained is legally privileged, and BAIN has taken great liberties, I must say, Chair, with describing me in all sorts of horrendous ways, like being dishonest and being disloyal and being disgruntled and being uninformed. I obtained that information in the context of being asked by BAIN to do the right thing for South Africa. And that was the context in which I revealed all of that information to the Commission. So that application, that attitude that I am contravening the intent of my engagement is strange to me.
Please look at Annexure AW12, page 147.
I've got it.
You'll see that that goes on to page 148 and then has terms of reference from 149 to 150. Is that the agreement which was concluded between you and BAIN and Company South Africa, Inc. on 7 September 2018?
That's correct, Chair. So subsequent to the one-page letter of intent, we then entered into this more comprehensive agreement.
I'm going to highlight certain parts of it. On page 147, Dear Athol, we are thankful that you have agreed to provide independent oversight of BAIN's investigations into its work at SARS. This service agreement, the agreement is effective as of September 7, 2018, by and between BAIN and Athol Williams, and I don't need to read the rest. This agreement describes how BAIN and or its affiliates may engage you to provide oversight of the investigation, defined as the services and how you will provide the services. It then contains various other provisions. What I'm interested in are the terms of reference that are referred to in the body of the agreement. Those appear at page 149 to 150. Is that correct?
That's correct.
Under the first heading, context, the first bullet point, it's recorded, BAIN is cooperating with the Nugent Commission of Inquiry, the Commission, to understand the facts of BAIN's engagement with SARS in 2014 and 2015. And then if I could look at the second bullet point, to reinforce BAIN's commitment to transparency to the Commission and to support BAIN's cooperation with the Commission, BAIN has secured the services of Athol Williams, a BAIN alumnus and a respected independent advisor. And the third point, BAIN's intent in securing Mr. Williams' services is that he does what is right for South Africa without restrictions. And then fourth, Mr. BAIN's role is to provide independent oversight of the external and internal investigations that BAIN are conducting. Just stopping there, please. Those are self-explanatory, but can you explain to the chairperson what were the internal and external investigations that are referred to here?
Chair, so I was not engaged to conduct any of my own investigation. BAIN had started, after Mr. Masoni's testimony, BAIN had started amongst themselves, amongst the internal legal team and some of the senior people, to begin to ask questions about what might have happened at SARS. So that was classified as the internal investigation. That was, I think, largely ad hoc, just to get a quick sense of what was happening. The external investigation was the investigation where BAIN had retained the services of Baker McKenzie, a law firm, to conduct a more comprehensive, a more thorough investigation, not only into what happened at SARS, but into BAIN's work in many of the SOEs, because BAIN had worked across most of the SOEs, including parts of government as well. So my role was And this was, there was, in my understanding, no precedent for this. There was no handbook I could go to. I didn't have training on how to provide oversight to an investigation. But the intent was clear. The intent was, Athol, we want to do the right thing here. We'll give you access to what Baker McKenzie is doing. You'll have meetings with him. You can see the documents. You make sure that at the end of this investigation, you can write a report where you give your assurance as an independent person. I might say, pseudo-independent, right? Because I was associated with BAIN, but I was now independent. You can give the public assurance that this investigation was independent and it was reported truthfully. So that's how I understood my role.
Right. Continuing with the terms of reference, at the bottom of the page, there's a heading, Operating Procedures. The first bullet point, Mr. Williams will have full access to the interim and final reports of the external and internal investigations and will have weekly meetings with the leads of these investigations. Just pausing there, what interim and final reports are contemplated as you understood it?
I think it's if that makes sense, Advocate Franklin, so the internal investigation sort of wrapped up very quickly. So it was, the idea was if that continued, I'd have oversight of it, but very quickly the internal investigation ended because the external investigation became the focus. But the idea was that Baker McKenzie and the team conducting the investigation would produce ultimately a report of their findings, which would go to the Nugent Commission. So that was the intent. And an interim, I think, if I remember correctly, we were mindful of the timing of the Nugent Commission. So the idea was to give the Nugent Commission an interim report, which would give him, the Commission, an update of the findings, but with a final report later on. So the understanding was that Baker McKenzie were going to produce these two reports, an interim report and a final report, and I was to have access to both of those.
And as it turns out, were you ever given access to an interim or a final report compiled by Baker McKenzie?
I was not, Chair. Despite my constant pleading for it and arguing for it, I was not given access during this contract at BAIN.
Right, then look at page 150 under the heading Outputs, the second bullet point, which says that Mr. Williams and the Commission are free to communicate directly on matters relating to the Commission's investigation, etc. And then it said, with respect to any such communication, first sub-bullet, BAIN agrees that it shall not deem any such communication by Mr. Williams with the Commission to be a breach of Mr. Williams's confidentiality obligations to BAIN. And secondly, BAIN agrees that it shall not seek to assert a claim of legal privilege to prevent Mr. Williams from bringing his concerns to the attention of the Commission. That mirrors, it seems, the similar two provisions that were in your letter of intent.
That's correct, Chair. Can I also just mention, because there's mention of the Commission, the Nugent Commission, I had, through the investigative journalist I'd contacted, established a connection with Judge Nugent. And so, again, to make this role of mine, which was already bizarre, even more bizarre, we established this understanding between BAIN, myself, and Judge Nugent that I was speaking to both parties. So Judge Nugent had a copy of my contract. He understood what I was there to do, and he welcomed comments from me, information from me. All BAIN knew about all of those the communications, but Judge Nugent welcomed communications from me. So this idea of being able to then communicate with the Commission if needed, I was free to do that in my contract. And Judge Nugent and I exchanged a number of emails and had one or two face-to-face meetings as well.
Right, we'll get into the detail of what was produced as a consequence of the investigation, but can I ask you to look at para 7, page 13 of your statement, or your affidavit rather.
Page 13. I've got it.
What you say is this affidavit relies on documents and emails that I received or produced during my 16-month period of engagement with BAIN. Now, just pausing there, could you give the Chair an idea of what document production exercise was carried out by whom And when were you shown such documents and on what basis?
So Chair, I think these documents can be divided into three categories by the three roles, different roles I played at BAIN, as the evidence leader described earlier. So during my role as this providing oversight of the investigation, like I said earlier, I had meetings with BAIN, with their lawyers, with the Baker McKenzie investigators. In fact, there were meetings I had with only the Baker McKenzie investigators without BAIN, so I had opportunity to ask questions and engage with them. What Baker McKenzie had started doing was because of the concern about the widespread possible improper behavior within BAIN, had begun accessing the devices of many of its personnel. So laptops, cell phones, looking at BAIN's server. So from that search, they had collected vast volumes of documents. Baker McKenzie went through a process of reducing that from, I think it was a few million documents, if I recall, down to a much smaller number. But all those relevant documents that they classified as relevant, those were shared with me. So that in fact, they'd all come to me by email. So there were periodic updates, face-to-face meetings, but also these documents that came into my possession as part of that role. So I was given these documents, or Baker McKenzie would alert me and others to something they'd found which I thought was relevant. So the bulk of the documents that I've got and I've presented to the Commission came during that period. So it was documents that Baker McKenzie had found from BAIN staff and shared that with me. I know it wasn't everything that was collected, because this idea of privilege emerged again. And so I don't know what the full set was that was collected. I just know what I received. But I know it was established that there were privileged documents that I wouldn't see. I'd only see the non-privileged documents. So that was that first period. Then in the second period, where I was this independent advisor with BAIN, helping them develop a remedy plan, I received no new documents on the investigation. So to the extent there are documents here, there are emails basically. And then the period when I was employed by BAIN, I received more documents and mainly emails. So when I say I produced documents, what I mean is I produced emails. I produced none of the documents.
All right, we're going to come out of the state capture inquiry, where Athol Williams, a former partner at BAIN South Africa, continues to give testimony. My colleague...
Right, and you have set out the process by which you received those documents in paragraph 7.1 and following of your affidavit.
That's correct. That's what I just described.
You also had face-to-face meetings with BAIN employees and with Baker McKenzie
Mr. Franklin, just remember not to speak too far away from the...
I'm sorry, Chair.
If it moves, you could move it closer if it's more convenient for you to put your file on the other thing.
Thank you, Chair.
Okay, all right.
What I had asked the witness is whether during the course of his engagement he had meetings with BAIN employees and also Baker McKenzie professionals.
I did, Chair. So a lot of the Baker McKenzie meetings were structured meetings around what they had found and whether I had any questions. The BAIN meetings were less structured. I was given access to the office, and so there were times where consultants would come into my office and raise their concerns, share their experience with me. So I got a sense from formally what had happened, but also from people in the coffee area or at the lifts cornering me and saying, I think you should know about this.
Right. Could I ask you your final conclusion before we get into the detail? What was it? Was it that BAIN had come clean with the Commission and with South Africa or not?
It was a definitive not. Like I mentioned earlier, Chair, I looked at my role as, did BAIN with Baker McKenzie conduct a comprehensive and rigorous investigation? And there largely I said yes, because I thought the terms of reference were adequately designed. I had these meetings with Baker McKenzie, so I knew where they were looking, who they were speaking to, what documents they were reviewed. So I felt comfortable with the comprehensiveness of the investigation. The parts I couldn't be comfortable with was I couldn't attend the interviews So I felt that those meetings where they were interviewing staff as opposed to just reviewing documents was very relevant, but those interviews were regarded as privileged. And I was denied access to the interview notes that came from those meetings. So I couldn't be sure of what happened in those interviews. In my view, it seemed comprehensive, except for the fact that I couldn't get access to those interview notes. On the truthfulness part, two parts. One, Judge Nugent kept writing to me, as he did to BAIN, saying that BAIN are being evasive, they are obfuscating, they are not, they were sending documents only when he asked for it. They were not addressing the real concern. So I knew what Judge Nugent's conclusion was. Mine was simple. I was hired to judge or form an opinion of whether BAIN had reported truthfully to the Commission. I was going to judge that by looking at BAIN's report to the Commission against all the evidence and discussions I've been part of. But when BAIN refused to give me access to the findings report, I could make no assessment of truthfulness. And in my mind, BAIN were therefore not truthful with me because I couldn't see the final findings, and they were not truthful to the Commission because they never submitted any findings to the Commission. And in fact, I've got evidence that suggests this was a conscious decision on BAIN's part to not file the report with the Commission and not to make that report available to me.
But you resigned from your engagement with BAIN at the end of 2019?
August 2019.
What led to that resignation, in a word?
It was BAIN continuing to withhold information I thought was relevant. I'd had all these assurances, and we read through those emails earlier, that BAIN had full intent to do the right thing. Part of doing the right thing, by my estimation, was to make full disclosure of what had happened. The fact that BAIN continued, even when I was an employee, a partner brought in to deal with these issues, they continued to withhold that from me, convinced me that I couldn't then be part of that. So it was the same issue that started in the beginning. It was this withholding of what had really transpired at SARS and other SOEs.
Right, could I ask you to look at para 9, page 15 of your affidavit?
I've got it.
Paragraph 9, page 15. If I could ask you to look 10 lines down. You say, it was only after I left and after BAIN made offers to me that I interpreted as being aimed at silencing me, did I really look closely at all the evidence in my possession and study it closely. This process started in late December 2019 and concluded in March 2020. A catalyst for reviewing what I had in my possession and organizing it was the summons I received from the Zondo Commission in January 2020. Putting together the contents of the 500 plus documents and emails, combined with the numerous phone calls and meetings that I attended at BAIN, plus my knowledge of BAIN, management consulting and business ethics, has allowed me to develop the sequence of events and understanding that I present in this affidavit. I think that's self-explanatory, but is that an accurate recordal of what in fact transpired? That you took a closer look at the totality of this evidence through the prism of your experience as a BAIN partner and employee, and put together what we have before the Commission today?
That's correct, Chair. In 2018, and during my oversight role, my work was really geared towards assisting the Nugent Commission, which was focused squarely on what was happening at SARS. So to the extent I looked at and reviewed evidence and had discussions with Baker McKenzie and BAIN, it was very targeted largely on what is happening at SARS. After I'd left BAIN, and when the Commissioner approached me and I said, I've got documents that I think might be useful to the Commission, I then looked at everything I had, not just what is relevant to SARS. And it's when I looked at everything I had, I actually formed a very different view than I had in 2018 when I was engaged to provide the oversight.
Right. And then in paragraph 45, page 27, you've also explained that in the sections which follow in the affidavit, you rely on information contained in documents and emails that were in my possession during the period of my engagement with BAIN, and that those are the ones you exchange with employees of BAIN or those conducting the investigation, i.e.
I'm sorry, Mr. Franklin, was 27 the paragraph or the page number?
45 is the paragraph, 27 is the page.
Oh, thank you. Okay.
Thank you, Chair. I was just highlighting that the emails and documents of those that I exchanged with employees of BAIN or those conducting the investigation, that is Baker McKenzie, or emails and documents that were given to me by employees of BAIN or the people conducting the investigation. Is that an accurate summary?
That's correct, Chair.
Chair, I'm about to proceed into the detail of the affidavit, and I wonder if this would suit the Chair to adjourn for the lunch break.
Yes, no, that's fine. We'll adjourn for lunch. We are meant to have the evening session for the continuation of Mr. Gordhan's cross-examination by Mr. Moyane's counsel this evening. The evening sessions normally start at 4 or 5. It may be that during the lunch break you might wish to consider what should be done at that time, and if need be, talk to all concerned. One approach is that we'll continue with Mr. Williams, stop at a certain time, maybe 5 o'clock, have that cross-examination take place, which I think should not go beyond an hour, and then resume with Mr. Williams after that. Now, I'm mentioning that alive to the fact that not everybody might be aware that my expectation is that we could go into the evening, but I know that a lot of people are aware now that we're trying to use as much time as possible to try and finish. So one option is that we would do that, but obviously it's subject to hearing if everybody that needs to be here or to participate is able to, or whether there are any problems. But I think to a very large extent people try to make a plan and cooperate and help the Commission.
Yes, we'll do that. Chair, just one issue. Of course, there will still be re-examination.
Oh yeah, there will still be re-examination, so that could take it beyond an hour.
Yes.
So that's one. That's the one option, is that would stop with Mr. Williams at a certain time, maybe 5 o'clock, maybe 6 o'clock. The other parties could wait a bit if we still continue a bit, but obviously not too long. We don't want to keep them waiting for too long. And then maybe, depending on how long the re-examination takes, most re-examinations that we have experienced in the Commission have been reasonably short. Then we need to see whether we would want to continue after that, or that would be too late for some of the people affected. As we approach the end of the time for oral evidence in the Commission, I'm more and more prepared to sit till quite late. But obviously that's not always convenient to everybody, and that has to be taken into account. So, but another option might be that we stop with Mr. Williams at a certain time, today, this afternoon, or early this evening, or whatever time, and then continue tomorrow morning with him and finish with him before we start the next witness. So I thought I would raise this thing so that maybe during the lunch break you could reflect, and so when we come back we can have some discussion. And to the extent that whatever we plan to do might affect people who are not here now, there might be a need for some discussion.
Yes,
But,
thank you, Chair. We'll
yeah.
investigate all of that.
Yeah, okay, all right. We'll take the lunch adjournment and resume at 2. We adjourn.